자, 데니스 케이스 보죠, 데니스. Okay, page 11, 15. Smith Act, Section 2. It shall be unlawful for any person to knowingly or willfully advocate, abet, advise, or teach the duty, necessity, desirability, or propriety of overthrowing or destroying any government in the United States by force or violence by the assassination of any officer of such government. It shall be unlawful for any person to attempt to commit or to conspire to commit any of the acts prohibited by the provisions of this title. So, this was applied basically against communism. Because the central tenets of communism is that capitalism cannot contain itself. So the workers of the world will unite to overthrow the state. Why overthrow? Because the state that exists, it exists to protect the private property. Actually, one of the most important functions served by the state was to protect private property. So in order to dismantle this private property system, they have to overthrow the government. Why dismantle private property? Well, it's a complicated logic, but communists believe that private property make people slaves to not to other people, but to private property, capital. They reasoned that capital has life its own, separate from its owner. Regardless of what the owners want, capital wants to increase itself, replicate itself, enslaving people, including the owners. So they thought that they have to overthrow. So that's the philosophy, okay? And so the entire Communist Party was considered illegal under the Smith Act. That's what the Smith Act did. Smith Act outlawed the Communist Party because one of the central teachings of the communism is overthrowing of a capitalist state that protects private property. So the question is whether this is consistent with freedom of speech. What does the court decide? What's the test that they apply? Yes, clear and present danger, page 1116. Paragraph 2. The rule we deduce from the Espionage Act cases. What are Espionage Act cases? We know them already. Schenck and Abrams. Is that where an offense is specified by a statute in non-speech or non-press terms, a conviction relying upon speech or press as evidence of violation may be sustained only when the speech or publication created a clear and present danger of attempting or accomplishing the prohibited crime. But it's interesting because both in Schenck and Abrams, freedom of speech lost. Remember? They were all, the convictions were affirmed. But now the majority is saying, oh, what we deduced from the previous cases, it's kind of ironic. They didn't deduce clear and present danger test from the majority opinions of Schenck and Abrams. They deduced it from not the holdings and not the decisions of the majority, but the reasoning of Holmes in Schenck and the dissenting opinion of Holmes in Abrams. Right? They kind of repainted their own history. They wrote as if the majority have protected freedom of speech in the past when they have not. But it's okay. What's more important is whether they want to do good from that point on. So, two paragraphs down, the court says, in this case, we are thus squarely presented with the application of the clear and present danger test and must decide what that phrase imports. We first note, now you are applying the clear and present danger test. We first note that overthrow of the government by force and violence is certainly a substantial enough an interest for the government to limit speech. If then this interest may be protected, the literal problem which is presented is what has been meant by the use of the phrase clear and present danger. And what does the court decide? About whether the clear and present danger existed. Page 1116, all the way at the bottom, the court says, likewise, we are in accord with the court below, which affirmed the trial court's finding that the requisite danger existed. The mere fact that from the period 1945 to 1948, petitioners' activities did not result in an attempt to overthrow the government by force and violence is, of course, no answer to the fact that there was a group that was ready to make the attempt. The formation by petitioners of such a highly organized conspiracy with rigidly disciplined members subject to call when the leaders, these petitioners, felt that the time had come for action, coupled with the inflammable nature of world conditions, similar uprisings in other countries, and the touch-and-go nature of our relations with the countries with whom petitioners were, in the very least, ideologically attuned, convince us that their convictions were justified on this score. So, conviction was affirmed. What do the dissent say? Page 1118, Douglas. If this were a case where those who claimed protection under the First Amendment were teaching the techniques of sabotage, the assassination of the president, the filching of documents from public files, filching is stealing, the planting of bombs, the art of street warfare, and the like, I would have no doubts. The freedom to speak is not absolute. The teaching of methods of terror and other seditious conduct should be beyond the pale. But, line below, the fact is that no such evidence was introduced at the trial. So far as the present record is concerned, what the petitioners did was to organize people to teach and themselves teach the Marxist-Leninist doctrine contained chiefly in 4 books. Stalin, Foundations of Leninism, 1924. Marx and Engels, Manifesto of the Communist Party, 1848. Lenin, The State and Revolution, 1917. History of the Communist Party of the Soviet Union, 1939. The opinion of the court does not outlaw this text nor condemn them to the fire as the communists do to literature, offensive to their creed. But if the books themselves are not outlawed, if they can lawfully remain on library shelves, by what reasoning does their use become a crime? All the way at the bottom of the dissenting opinion, how it can be said that there is a clear and present danger that this advocacy will succeed is a mystery. In America, the communists are miserable merchants of unwanted ideas. Their wares remain unsold. 안 팔린다는 얘기죠. 아주 인기 없는 사상이다. The fact that their ideas are abhorrent does not make them powerful. 사람들이 이렇게 혐오하는데 이게 그렇게 설득력 있는 아이디어라는 게 말이 안 된다는 얘기죠. Thus, if you are to proceed on the basis of judicial notice, it is impossible for me to say that the communists in this country are so potent or so strategically deployed they must be suppressed for their speech. So, you can ask this question. Clear and present danger test was authored by Justice Holmes. And in illustrating how clear and how present the danger has to be, he used the analogy to crying fire, falsely crying fire in a crowded theater. Are the majority in this case applying the clear and present danger test correctly? What do you think? Is there as immediate a danger in Marxist Leninism as in falsely crying fire in a crowded theater? Does teaching of Marxist Leninism suddenly trigger people's panicked behavior that can cause a stampede? Manifesto of the Communist Party is something I learned in college at Harvard University. Actually, whole year I studied German philosophers, Kant, Hegel, Marx, Nietzsche. So when I studied Marx, I learned Manifesto of the Communist Party and many other teaching, and of course, Das Kapital. None of the classmates turned out to be communist. None of us joined communist guerrilla. Think about that. And then we go to page 1124. Brandenburg versus Ohio. So, by the way, I mean, you can compare the Dennis case to a certain case in Korea that happened 2 years ago. 통합진보당 해산 사건이죠. So, Unified Progressive Party was outlawed by the Constitutional Court. The same court that impeached the President Park. So back in 1951, 60 years ago, the US Supreme Court was no better. What's interesting is, as Justice Douglas says, after the Dennis case, well, people continue to teach Marxist-Leninism. Probably not in any, probably some in ideological way, but also in, objective academic way that students are taught. Who went to college at Korea University? Anyone has studied? Anyone had a chance to read Marx in any of the general education classes? Okay. Well, philosophy department is dying in all colleges in Korea, so maybe that's the reason. But outside Korea, all major colleges offer some parts of Marxism as their general education regiment. But anyway, let's go to Brandenburg versus Ohio. And you can compare how the clear and present danger test has been used. The facts are very interesting, so I'll actually read together with you. Page 1124, the bottom paragraph. The record shows that a man identified at trial as the appellant telephoned and announced a reporter on the staff of a Cincinnati television station and invited him to come to a Ku Klux Klan rally. What is Ku Klux Klan? It is a racist party, basically, that believes in white supremacy. Rally to be held at a farm in Hamilton County. With the cooperation of the organizers, the reporter and a cameraman attended the meeting and filmed the events. Portions of the films were later broadcast on the local station and on a national network. The prosecutor's case rested on the films and on testimony identifying the appellant as the person who communicated with the reporter and who spoke at the rally. The state also introduced into evidence several articles appearing in the film. 소품들이죠, article, 소품. Including a pistol, rifle, shotgun, ammunition, a Bible, and a red hood worn by the speaker in the films. One film showed 12 hooded figures, some of whom carried firearms. Hooded, 무슨 얘기 하는지 알죠? 가면, 이렇게 뾰족하고 눈만 뚫려 있는. 이게 이제 50년대, 60년대 그 흑인들 한테 폭행을 할 때 자기들의 신원을 가리기 위해서 쓰고 다녔던 거죠. One film showed 12 hooded figures. They were gathered around the large wooden cross which they burned. No one was present other than the participants, the newsmen who made the film. Most of the words uttered during the scene were incomprehensible when the film was projected, but scattered phrases could be understood. They were derogatory of Negroes and in one sentence of Jews. Another scene on the same film showed the appellant making a speech. The speech was as follows. This was organizers' meetings. We have had quite a few members here today, which are We have hundreds of members throughout the state of Ohio. I can quote from a newspaper clipping from the Columbus, Ohio Dispatch. 5 weeks ago, Sunday morning, the Klan has more members in the state of Ohio than does any other organization. We are not a revengeant organization, but if our president, our Congress, our Supreme Court continues to suppress the white Caucasian race, it's possible that there might have to be some revengeance taken. Okay, we are not a revengeant organization, but revengeance have to be taken. We are marching on Congress July the 4th, 400,000 strong, of course. Nowhere near 400,000 people show up. They're just bragging. Hyperbole. From there, we are dividing into two groups, one group to march on St. Augustine, Florida, the other group to march into Mississippi. Thank you. The second film shows 6 hooded figures, one of whom later identified as the appellant, repeated the speech, very similar to that recorded on the first film. The reference to the possibility of revengeance was omitted. One sentence was added. Personally, I believe the niggers should be returned to Africa, the Jews should return to Israel. Though some of the figures in the film carried weapons, the speaker did not. Okay, that's the speech. What's the law that the state tried to apply? Well, Ohio Criminal Syndicalism Statute. What does it say? It says, advocating page 1124, first paragraph. So advocating the duty, necessity, or propriety of crime, sabotage, violence, or unlawful methods of terrorism as a means of accomplishing industrial political reform. And all voluntarily assembling with any society, group, or assemblies of persons formed to teach or advocate the doctrines of criminal syndicalism. What does the court say? Does the court apply clear and present danger test here? Yes, sort of. Page 1125, all the way at the bottom. These later decisions have fashioned the principle that the constitutional guarantees of free speech and free press do not permit a state to forbid, proscribe advocacy of the use of force or law violation, except where such advocacy is directed to inciting, producing imminent lawless action and is likely to incite or produce such action. So imminent lawless action, that's present. It's likely to incite, produce such action, that's clear. Clear and present danger test. It's rephrased, but it's similar. And what does the court say? Page 1126, third paragraph. Accordingly, we are here confronted with a statute which, by its own words and as applied, purports to punish mere advocacy and to forbid, on pain of criminal punishment, assembly with others merely to advocate the described type of action. Such a statute falls within the condemnation of First and 14th Amendment. The contrary teaching of Whitney was a previous case that upheld the same statute, cannot be supported, and that decision is therefore overruled, reversed. The first time freedom of speech was applied to save individuals, it saved white supremacists. So this is why a lot of people hate the Supreme Court justices on freedom of speech. They denied using freedom of speech. They denied freedom of speech to a lot of good people who wanted to, change the world. Without engaging in any violence or without carrying any firearm. Remember Schenck? It was a leaflet, right? Leaflet that says, do not submit to draft. In Abrams, it was a leaflet do not send the army to Russia. In Abrams, they were just teaching Marxism. There was no gathering of people with firearms. There was no planned threat of violence. Here they are threatening violence. They are wearing the same hood that was used in 50s and 60s in lynching, right? In mob lynching innocent black people in the South. And burning the cross was also part of the practice, part of the ceremony of beating the blacks. And they'll march in these numbers. I wanted to point out, the march is going to split into two. One go to DC, the other into Mississippi. Why Mississippi? Because a lot of blacks live there. And that's where many houses were burned, many black people are beaten. So they wanted to go remind the blacks of what they believe is the low status that they should belong to. But Brandenburg versus Ohio, because it's a really bad case, it kind of set the outer limit. It's the most heroic act of the Supreme Court in protecting freedom of speech. If this can be protected under freedom of speech, a lot of things can be protected. I mean, if Schenck was decided again, if Abrams was decided again, after this was decided in 1969, right? If all these cases were decided, Abrams, Dennis, they were decided after Brandenburg, they'll all be set free. So that's the modern rule of clear and present danger. And I gave you this case, U.S. versus Rutherford. What's this case about? It was a Baum-Hawkes law. So, if you look at page, okay, now you can use the bottom page number. Bottom page number 93. Section 35A. So, the left second paragraph, it says, Section 35A, under consideration in this case, makes criminal the imparting of information. 그러니까 spreading information, 그런 뜻이죠. Imparting of information, knowingly the information to be false, concerning an attempt or alleged attempt being made or to be made to any act which would be a crime prohibited by the chapter. And what's the crime? Planting of a bomb. Okay. So basically, falsely, I'll read more. Thus, the statute would be violated by imparting of knowingly false information with respect to an attempt about to be made to damage an aircraft in any way, irrespective of the saboteur's intent, or to damage a motor vehicle in any way with the intent to endanger the safety of any person on board. What did he say? What did the defendant say? The defendant was in the airplane, And he said, probably joking, I have to sit near the back because I have a bomb. Okay. So if the airplane is long, if the bomb explodes in the back, only the people in the back get blown away. But if the bomb explodes in the front, the whole airplane gets shrouded in smoke and flame from the front. So he was saying, oh, let me go sit in the back because I have a bomb. Was joking, but so he was charged with violation of this law. What do you think about this law and the conviction, his conviction under the law? How does it compare to the analogy of a falsely crying fowl in a crowded theater? Is this like it or not like it? The court upholds or strikes down the statute. The court upholds the statute, saying this is consistent with the clear and present danger test. The court says, left third paragraph, page 93, lower page number 93, left third paragraph. If the statute, so far as it applied to aircraft, were limited to making criminal the imparting of a false information with respect to the existence of a bomb on a loaded aircraft, there could be little doubt that the giving of the false information would be beyond the protection of the First Amendment. It would fall within the principle of the false cry or fowl in a crowded theater, mentioned here. The classic illustration of an unprotected speech given by Mr. Justice Holmes. Such speech is characterized as a verbal act. So, in distinguishing expression from physical act, this is like in between. It's a verbal act. 표현적 행위다 이런 얘기. So if you remember Schenck, Justice Holmes says something like, if the words have a force, then it should be restricted, right? So these are the words that have force. Why aircraft? Why motor vehicle? If you look at the statute, only the bomb, only false alert of a bomb in aircraft or motor vehicle, right? Only bomb hoaxes on those spaces are punishable under the statute. What's the difference? Well, think about it. Okay? Think about why that helps satisfy clear and present danger test. That's it for today, and we'll talk about defamation next week. And next week, next Wednesday. And I'll put on Blackboard when it will be, where it's going to be held.